order. For those who may not be aware, there was a last-minute change. Our chair is unable to attend this morning, and so this morning I was asked to resume the chair role as the vice chair of this committee. And as you're aware as well, I am the lead for the Conservative team and generally lead our questions, so I will be leading my questions as well, unless there are any issues with that. But I would like to say to the committee that I will ensure respect for the time and ensure that our standards are maintained in this committee during my questioning period. So welcome to the meeting number 32 of the House of Commons Standing Committee on Public Safety and National Security. Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Pursuant to Standing Order 1082 and the motion adopted by the committee on Thursday, June 23, 2022, the committee is meeting on its study of allegations of political interference in the 2020 Nova Scotia mass murder investigation. A reminder that all comments by members and witnesses should be addressed through the chair. When you are not speaking, please ensure your mic is on mute. I would like to now welcome our witnesses for the first panel. Department of Justice François Degel, pardon me if I've mispronounced your name, sir, Deputy Minister of Justice and Deputy Attorney General of Canada, and Owen Rees, Acting Assistant Deputy Attorney General. Deputy Minister, I will now open the floor to your comments. Please go ahead.
Thank you, and thank you for inviting us to appear before the committee today. As Owen was introduced, he's joining me today. He's the Acting Assistant Deputy Attorney General responsible for national litigation, our national litigation sector in the department. Before I begin, I'd like to offer my deepest condolences to the families and the loved ones of the victims of the shooting in Nova Scotia in April 2020. I want to acknowledge their loss and the impact of those events on the community. My remarks today will focus exclusively on the process led by the Department of Justice to produce documents to the Mass Casualty Commission. The Department of Justice and its lawyers were not involved or consulted on whether to disclose firearms information at the April 28, 2020 press conference, nor were we involved in the teleconference with the RCMP Commissioner that followed that day. So as a result, I really don't have any relevant information to provide on your questions on allegations of political interference in 2020. So I'll therefore focus my remarks on the role of the Department of Justice before the Commission and on the document review and production process, including the disclosure of 4 pages of officers' notes related to that April 28, 2020 teleconference. And given that our time is short and that document production processes are complex and detailed, I have sent to the committee last Friday a letter detailing, providing more information about the document production process and our role before that commission.
Department of Justice lawyers represent the Government of Canada in the Mass Casualty Commission's investigation. One of the responsibilities of our lawyers and paralegals is to disclose relevant documents for the purposes of the inquiry, which is standard in public inquiries and civil litigation. The disclosure of documents in any investigation is a significant task. The government has already disclosed over 75,000 documents to the Commission. The magnitude of the work is significant given the logistical challenges of collecting, reviewing, and disclosing each of these documents. It is a technical and complex process that requires a great deal of effort and time. And I would like to acknowledge the dedication of the Department of Justice employees who did this important work. In the context of this inquiry, disclosure of documents is an ongoing process. The government began disclosing documents to the Commission in February 2021. As the Commission continues its investigation, new issues are raised, and that results in new document requests. That is, again, normal in this type of inquiry. As a result, our team of lawyers and paralegals regularly receive new document requests from the Commission and receive new sets of documents for review from the various government departments and agencies. The departmental team sorts through these requests based on the board's immediate needs and the priorities of upcoming hearings.
A standard feature of document production in this inquiry and in civil litigation generally is the review of documents for legally privileged information. Privilege can apply to entire documents or to portions of documents according to common law or statute, like, for example, the Canada Evidence Act. I want to be very clear with the committee that This document review and production process, the production to the Commission, is managed by the lawyers and the paralegals in the Department of Justice. The Minister of Justice and the Minister's Office are not involved in this process. As part of the document production process in early 2022, we reviewed the handwritten notes of 4 senior RCMP officers in order to produce them to the Commission. There were over 2,400 pages of handwritten notes. And as outlined in my letter, our team flagged 35 pages among those 2,400 as containing potentially privileged content. And knowing that there were hearings coming up with these officers, we decided to authorize the disclosure of the 2,400 pages, but with the exception of the 35 pages that we are still reviewing for privilege. Unfortunately, we did not alert the Commission to the fact that we had not produced the additional 35 pages because they were being reviewed. We've exchanged letters and spoke to Commission counsel, and I think the oversight was acknowledged and understood. 4 of the 35 pages only relate to the April 28th
10
meeting.
seconds, sir.
Can I finish? Yeah. I just 10 seconds. Only 4 of the 35 pages related to the April 28th meeting. These were in the notes of Superintendent Campbell. And after our review, all of those documents have been produced without redactions. They were produced on May 30th to the Commission. The rest of the 35 pages, the 31, were also produced subsequently, some with redactions for irrelevant information. So we continue to work closely with the Commission sur le processus de divulgation.
On the disclosure process, the government is fully committed to supporting the Mass Casualty Commission's work
And professionalism of our Department of Justice lawyers and paralegals that are representing Canada before this Commission. Happy to take questions.
Thank you, Mr. Deputy Minister. Colleagues, we will start our line of questioning. Oh, sorry, go ahead. Oh, was there any other comments from you, Mr. Rees?
No, thank you very much.
Okay. Thank you very much. Thank you, Clerk. Colleagues, we will start our round of questioning. The Conservatives will begin with 6 minutes in our first rounds, and I will begin that round of questioning for us, and I will begin my 6 minutes now, and colleagues are welcome to keep me on time as well. Thank you. Thank you very much again for both being here today, being forthcoming with that information, your opening remarks, Mr. Deputy Minister. You're aware that the Mass Casualty Commission has a public interest mandate to investigate the worst mass murder in Canadian history to get answers for the public, correct? The Department of Justice also has the obligation to assist the Commission in achieving its mandate to serve the public interest, correct?
Agreed.
You're aware that Chief Superintendent Chris Leather recently testified that at the Commission inquiry that he received legal counsel from the Department of Justice, your department, to withhold evidence from the Commission unless specifically asked. That is, your department, the lawyers in your department, the counsel, told him to provide evidence reactively and not proactively. Is that correct?
That is correct, but only with respect to the, I guess what's referred to now as this wellness report. So I have 3 reasons, really, to explain why I think Chief Superintendent Leather misunderstood the advice that he received. First, we learned of this. I guess our council met with Chief Superintendent Leather on July 5th, and it was during that meeting that we learned of the existence of this wellness report for the first time. It was, from what I understand, a report that was commissioned a year after the events. What we counseled Chief Superintendent Leather to do was, because we hadn't seen the report yet, we didn't know to the extent to which it was relevant, if all of it was relevant, portions of it were relevant. It was obviously prepared for a different purpose. And so our advice to him was, don't raise it proactively, but if it comes up, answer the questions. That was the advice we gave to him. We gave no advice with respect to being reactive or not being proactive with respect to 2 other pieces of information. One was about the April 28th meeting, because that information was already before the Commission, and we like all witnesses, we told them to be very
Thank you, sir. So just to be clear, you're saying that there was another one. We've been hearing a lot of these misunderstandings, as I'm sure you are aware, during this investigation. So you're saying that Superintendent Leather misunderstood, but that in fact your department did advise him to be reactive and not proactive, but it was specifically in terms of this wellness study that was being undertaken for Nova Scotia RCMP. But he was under the impression that that reactive approach was to be taken at large whenever he was asked questions by the Commission or otherwise. So it's odd that that misunderstanding is quite significant, I would say, and he shared that at the Commission. So are you aware then that the Honourable Thomas Cromwell, Council Director of the Commission, wrote to Department lawyer Laurie Ward? I'm just going to pause. Can we ensure we're all muted? Thank you very much. I'm going to resume my time. Thank you. You're aware of this letter sent to the Department of Justice on August 6th from the Honourable Thomas Cromwell, Commission Council Director. He was not familiar that this was a misunderstanding. He is under the impression that your department, in fact, asked Mr. Leather to be reactive in his testimony. Are you aware of this letter that I'm referring to?
Letter says is that he is concerned to have heard of Chief Superintendent Leather's testimony and is asking us to confirm whether that's correct or not correct. And we have responded to that letter. Laurie Ward did respond to that letter on August 9th to explain what I just explained to you a minute ago.
Have you advised anybody else to be reactive in their approach to the wellness report or the Commission generally, anyone involved in this case in the RCMP or otherwise?
No, this was a comment we made to Superintendent Leather because it came up when we were preparing him, or our council were preparing him for an interview with the Commission Council the very next day. So he brought it up at the prep, and we had never seen this report. So it's reasonable for us to say, well, before we'd like to see it and give you some advice before before you raise it. But if questions come up, you have to answer the questions.
Thank you, Mr. Deputy Minister. So to be clear, you have not advised anyone to be only reactive and not proactive.
No, and with every witness before the inquiry, we have counseled them to be truthful and to assist the Commission as much as possible. So at any time
since the 2020 Nova Scotia mass murder, was the department concerned about political interference from government? At any time did you advise anyone about political interference?
No, as I said in my opening remarks, we were not involved, or nobody sought legal advice on this April 28th meeting with respect to the disclosure of firearms information.
Thank you. And have you provided, so you have not provided any legal advice to the Prime Minister's office, the Public Safety Minister's office, or any other ministerial office concerning the mass casualty?
Well, we've provided lots of advice to the government, but I think the allegations are with respect to the firearms information at this April 28th press conference and the subsequent meeting with the Commissioner.
So
we have not provided any advice with respect to those.
Justice Canada spokesperson Ian McLeod said that the final 4 pages of Chief Superintendent Campbell's notes were withheld until the end of May of this year because they, quote, required further assessment of whether they were privileged or very aware of this. What aspect of their content merited that further assessment that took that additional 3 months to release Mr. Campbell's notes? Again, you'll remember it's those 4 key pages that have really initiated this entire investigation.
Yeah. And I've said earlier, those 4 pages were caught up in another group of 35. There were 35 pages altogether that we'd flagged. We flagged things for further review. Some things are legal advice. That's easy to spot. Some things may be cabinet confidence. Some may be public interest privilege. And depending on the nature of the privilege, our council have to consult other people. So it takes time to review them, especially since they're handwritten, and sometimes we have to go back to our clients to understand the context within which those comments were made. So the privilege review does take some time.
Great, thank you. Our time is up. And so we're going to go now to the Liberal Party. MP Noor Mohammed, you have 6 minutes.
Thank you, Madam Chair. Mr. Deputy Minister, great to see you here today, as well as your colleague. Thank you very much for coming. I want to just follow up a little bit on the questions that my colleague, Madame Danter, just asked. And I wanted to start off where she ended. There was this conversation that this comment you just made about the fact that these 4 pages were caught up in the 35 pages. And, we want to be very, very clear with folks as to why those pages took a little bit longer to ensure that they were reviewed. Can you give us a very brief synopsis as to what that review process looks like and why that might have taken a little bit longer to do?
Privilege review process takes time, not just with respect to these 35 pages, but all of our review processes, depending on the nature of the information and the privilege that's been identified. But you can imagine if, for example, somebody mentions a Treasury Board submission or a cabinet document in their notes, we have to review it, find out what it's about, track down some people who have information about it, usually consult the Privy Council office to see if this is a cabinet confidence or isn't, depending on the tests from case law or from the Canada Evidence Act from Section 39. So that takes some time, and we have to consult others before we can get to complete the review.
And during your review, is there a consideration for quote unquote politics, whether or not there are going to be political implications for the government?
As I've said, so for us it's a legal test. Obviously we want to provide all the information that we can to the Commission, given its mandate and given the importance of getting to understand what happened. And so it's really a legal process that's done by our counsel and our paralegals in the Department of Justice. And as I've said, our Minister's office has not been involved in any of it.
So would it be fair to say that Department of Justice lawyers don't read something and say, oh, that might be damaging to the government, we should withhold this?
Is whether it's relevant to the Commission. And if it's relevant, it needs to be produced, subject to some privileged information that may have to be redacted.
Did you or your department ever instruct that any information that should have been disclosed to be withheld? Would you ever do that?
No.
Why not?
Well, because the mandate of the Commission is very clear. Our job is to assist the Commission, and we'll provide them with all the information in the possession of the government that's relevant to their mandate, so they can discharge their mandate. And
just for further clarity, what is the relationship of Department of Justice lawyers with the Minister's office, if any?
Well, the Minister is the Attorney General of Canada as well. He is accountable to Parliament for the work of our department. All of the employees in our department work on his behalf to discharge the obligations under the Department of Justice Act at Sections 4 and 5 of our Act.
And the Act specifies that there cannot be political interference, or the Act does not allow for political interference by the Minister of Justice, correct?
There's nothing in the Act that says that that talks about political interference. No. Just so that I can clarify the question, would there be a circumstance in which the Department of Justice would be concerned in this situation? Was there a situation where the Department of Justice lawyers, the bureaucrats, would be concerned that they were getting political direction from the Minister's office to withhold anything? As I said, our Minister's office and the Minister were not involved in any of the work being done by the department to support the government before this Commission. So I had no reason to be concerned about political interference. There were no discussions with the Minister about this.
So there were no discussions with the Minister. You never instructed Department of Justice lawyers to withhold information. Why do you think this misunderstanding that Mr. Leather had would have come about? You talked about the circumstances around this. Why do you think there would have had that misunderstanding?
Chief Superintendent Leather why, but I think you've already heard some testimony from the Commissioner and others on that issue. As I said, we were not involved at the time. We didn't provide advice, so I really don't have anything I can offer on that.
And you were comfortable with the way in which Department of Justice lawyers have provided information in a timely fashion and handled the redaction process where required, and consulted with the appropriate folks to ensure that nothing is being withheld unreasonably, correct?
Absolutely. As I said, it's a very complex process and with some tight timelines, and I think everybody is doing their best to support the government and to support the Commission in its work. And I have full confidence in our counsel.
20 seconds, Mr. Nur Mohammed.
Thank you. I will yield the rest of my time to the Chair.
Thank you, sir. All right, we're going to go to the Bloc québécois. Député Normandienne, s'il vous plaît.
Merci beaucoup.
Thank you very much, Madam Chair. Thank you, Mr. Daigle and Mr. Rees, for being here today. Mr. Daigle, I'd like to start with a question about your letter from August 12th, talking about the mechanism of producing documents to the Commission. You talked about the process of redaction and how it's done, but it doesn't talk about what happens to documents when they're being analyzed. And that's really what we're interested in when it comes to these 4 pages. They were withdrawn. They were not actually redacted. So I'd like to know, why does your letter not discuss what happens with documents that are actually being analyzed for potential redaction? I'm not sure I've really understood the question, but the process is that we receive documents from the department or the RCMP. We usually receive them electronically. We put them through our document management system, and then they are sorted into categories. So we had a category for notes from RCMP members, RCMP officers. That was around 2,400 pages. And we went through all of those documents. And during the process, we identified that there were some passages in some of those notes that may require privilege. So we decided to give the Commission the 2,400 pages right away because they needed the documents urgently, and then just to continue our further analysis of those 35 pages. Our legal counsel had the 35 pages and then consulted colleagues about them before concluding that the documents, before making any conclusion about the documents. And if they didn't fall under privilege, then they would be given to the Commission. And if they did, then we obviously would have conducted a redaction. So I understand what you're saying. So it's really about the question of withholding these documents. Have I understood correctly when you say that you started analyzing those 35 pages in January or February of 2022, and that they were only produced to the Commission in May? So there were about 3 months during which they were withheld. Is that correct? Yes, but during that time, we weren't twiddling our thumbs. We were working very hard at analyzing these documents. The Commission's priority at the time was to look at the investigative files, and that was their focus. So it was later, when we were preparing for the RCMP hearings, that the Commission said, okay, we need these documents, and then we expedited that process so that we could get the documents ready for them. It took us about, as you say, around three months to do that. And I certainly wasn't accusing you of anything, but I would just be curious to know, during that 3-month period, I imagine that there were some accounts, there were some updates given to department officials about the legal situation. Surely there were some discussions happening. So in that context, did anyone say, oh, the Commission doesn't know that there are actually these 35 pages missing? Well, we should have, and as I said, the lawyers should have advised the Commission right away that there were these extra 35 pages being reviewed, and we didn't do that. And that's obviously what led to these questions. We did subsequently exchange correspondence with Mr. Cromwell and the Commission to explain the process, and then we agreed on a process for going forward so that the Commission would be aware of any documents that we did believe were relevant but had not yet been disclosed because they were still under review. Great. So just so I understand correctly, it's when you received those documents on May 30th that the Commission then understood that 35 pages were missing. So during the 3-month period from February to May, the Commission didn't know that pages were missing. Is that correct? So they were not aware that there were those 35 additional pages that we believed were relevant but had not been provided. Sorry, I just missed the very beginning of what you said. I believe it was June 22nd that Mr. Cromwell wrote to us mentioning, the 4 pages that were missing, and that at that point we sat down with the Commission and explained what had happened. In your letter from August 12th, at the very beginning, you say that a party needs to disclose documents that are relevant to a commission if they're not subject to privilege. Now, I understand that you started collecting documents for the commission around November 2020. So shortly after the commission was created on October 21st of that year. So I'd like to know, in terms of the document collection process, are there some documents that are automatically given to the commission, or do they all need to be subject to a subpoena in order to be produced? I'll ask my colleague Mr. Rees to explain that. After the documents are collected, the lawyers and paralegals at the Department of Justice begin their revision process to determine whether documents are relevant. We started disclosing documents to the Commission in February 2021, before the subpoenas were issued by the Commission.
C'est un processus.
But it is an ongoing process.
Merci,
Merci
Député
beaucoup.
Normandin. Merci.
Thank you very much.
The New Democratic Party, MP McGregor, please, 6 minutes.
Thank you very much, Madam Chair, and thank you, Deputy Minister, for appearing before our committee. And also, I'd like to thank you for the letter you provided to our committee, just explaining the process before we held today's meeting. Now, in your letter, you mentioned that the 35 pages that were held back, they were retained for further review. Of those 35 pages, they actually contained 4 sets of notes. I think there were some from Superintendent Campbell, there were some from others. So out of that 35 pages, 13 of them were from Superintendent Campbell's notes that were held back. And so out of the 13 pages from Superintendent Campbell, it's the 4 of his 13 pages that specifically referenced the April 28th teleconference with the commissioner. What I would like to know from you, Deputy Minister, is when your officials were looking at those 13 pages from Superintendent Campbell specifically, were they looking at the 13 pages, were they sequential nature, like were they all written in one sequential line, or were they 13 individual pages that were sort of handpicked out of the entirety?
I'm not exactly sure how they were, but from what I saw, we have the entire, books of notes from the RCMP officers from, a certain date to a certain date. And we've identified throughout what was relevant to the commission, and from that, what we thought needed a review for privilege. So are they sequential? I think they are consequential in the sense that the books start at one date and they go forward. So when we get to April 20th, there's some notes. When we get to April 28th, there's some notes, and then and so forth. So
just to be clear, you're not aware if the 13 pages that were held back from Superintendent Campbell specifically, you're not aware if those 13 pages were actually written sequentially in a specific timeline, like a journal entry. You're not clear of that information?
Journal entry. Maybe Owen's had a look at this and can provide more information.
My recollection is that they were in chronological order, as one would take notes in a notebook, and that the 4 pages were in chronological order in a date
Thank
range.
you. And you've taken some time to identify the kinds of privilege that might exist, why they were withheld. Would notes referencing a phone call with the commissioner, would that constitute something that people in your department might take as privilege? Were they concerned that the handwritten notes of a teleconference might contain sensitive information? 4 pages out of 13, that is actually a significant percentage to hold back. I'm just trying to get a sense of the thought process of your department's lawyers that led to those 4 pages being held back.
Pages of over, hundreds of pages of documents from Superintendent Campbell, 4 of those 13 pages that we held back dealt with the April 28th meeting, right? So we didn't just hold back the 4, we held back the 13. And in answer to your specific question, if it's just a reference to a phone call with the commissioner, there's nothing privileged about that. From, on the face of an entry in a document, so we wouldn't have flagged that for review. We would flag for review if there's, a reference to a cabinet meeting or a reference to a Treasury Board submission or a reference to legal advice. Those would be flagged.
Thank you, Deputy Minister. Sorry for interrupting. My time is short here. Yeah. Can you explain to us who is the ranking person in the Department of Justice who makes the final call on whether information is to be considered privileged or not? Well, like what level of person in your department makes that final call?
So for the commission, for the work that we're doing for the commission, so we have a team of lawyers. They're led by Laurie Ward, who's our most senior counsel there. And so she's
Laurie Ward would have made the call?
Well, it could be somebody within her team, depending on how they've sorted out the responsibilities within the team. But counsel are able to make that determination after consultations whether a document is privileged or not. And
but
this is something that all lawyers do, right?
She would ultimately be responsible for the decisions made in her department on that final call on what information is to be considered privileged or not, right?
Well, she's responsible. She's leading the team that's supporting the commission. So ultimately, all of the decisions that the team is making, she would have some accountability for, yes.
Thank you. In your letter, you referred also to times when there might be a conflict between the MCC and the Department of Justice. Like if the MCC raises questions about determinations of privilege, there are meetings held between your department and the MCC to find a way through it. Could you explain, I don't have a lot of time, but how generally are those resolved and have they been resolved satisfactorily to date?
10 seconds.
It's a phone call to Tom Cromwell or somebody else on the Commission Council team.
Okay.
All the time we have. Thank you, MP McGregor. And now we're going to go to the second round. And to start off with the Conservatives for 5 minutes, we have MP Ellis. MP Ellis, you have 5 minutes.
Thank you, Madam Chair, and thank you, Deputy Minister, for being here. As you may or may not know, I'm the Member of Parliament for Cumberland-Colchester, who would represent many of the victims' families of this terrible occurrence in my riding. The crux of this matter, sir, of course, is related to not just accountability, but transparency and honesty. And I guess the big question that I would suggest that people really want to understand better is there's two parts. One is, you said we're going to provide all of the information we can, which doesn't necessarily sound transparent to me. That's my judgment. Secondly, you talked about Chief Superintendent Leather being misunderstood. And let's start with that, sir. Would you not expect that the lawyer, I would use the word cautioning, Mr. Leather would make sure that he wanted to be understood, that reactive versus proactive nature would want to be understood very clearly?
Yes. Yes, I think everybody wants to be understood, and the advice needs to be as clear as possible.
I guess then, sir, how would you come to the conclusion that it was Chief Superintendent Leather who misunderstood the directions given to him?
So I have, as I said earlier, I have 3 reasons to believe that. One is our advice was, because we didn't know what this report was, not to raise it unless the Commission raises it. So that was the extent of our advice in terms of being reactive or not proactively talking about this until we had and this was, remember, this was July 5th, and he was only appearing on July 27th. So our view was that we'll have time to get the report, look at it, determine its relevance, and figure out whether it can and can't be. So our advice to him was, look, it's the first we hear of this. We haven't seen it. Don't raise it if they don't raise it, but if they do, you'll have to answer. The other reason we think that he misunderstood is because he suggested during his testimony that we also told him not to provide information about the April 28th meeting. And that makes no sense, sir, because all of the information about the April 28th meeting was already before the Commission. So there's no reason for us to suggest that. There's also his reference to his call to the Commissioner on April 22nd. We learned about that when he testified on the 27th. It's not in his notes, and so for him to suggest that we told him not to talk about a meeting that we'd never heard about doesn't make sense. So that's why my conclusion is that he misunderstood the advice. Our advice was only specifically with respect to the quintet report because we didn't know anything about it at the time on July 5th.
Sir, do you think it's possible that Chief Superintendent Leather understood the direction he was giving, and perhaps that there was a interference here in getting the truth out? You don't believe that, sir?
Ask Superintendent Leather. I don't know what he was thinking. All I know is what he told the committee on the 25th.
Well, it's interesting, sir, that you know that he misunderstood his directions. That's the unusual thing, but you don't know what he was thinking. The second part of the questioning, sir, how can the families, the victims of these families, be certain that there are no other documents being withheld by your department?
So we gather documents from 7 departments and agencies, and we review them for relevance, and if they're relevant, they are produced, unless parts of them or all of them have to be retained for privilege, based on the Canada Evidence Act or other legal privileges. So how can they be assured? Well, we've produced 75,000 documents already, and we keep responding and have a very good relationship with the Commission and its council to produce everything that is relevant so that this Commission can get its job done.
But, sir, we also know that you didn't report back to the committee originally. When you withheld documents, you didn't make them aware of that fact. And, of course, you continue to talk about this voluminous number. Fantastic. We understand there is a lot of documentation, but there is absolutely no assurance here for the victims' families to say that, yes, all of these documents have been produced and are going to be made available to the MCC. How can you reassure us, sir, that that's going to happen, or can you?
I am reassuring you that every document that we are provided with at the department will be reviewed for relevance, and if they're relevant, they'll be produced. And this happens on a weekly basis. So information that came out at the hearings of this committee on the 25th, we learned some new things, and we've tracked it down and produced. For example, Chief Superintendent Brennan's notes were raised for the first time at committee, and we've since tracked those down and produced them. So anything relevant, we will be producing to the Commission. And with respect to the 35 pages that we didn't, we held back for review, yes, we should have told the Commission that we held those back until we were done for review, but our intent was always to review them and to produce them. And that's a process that we'd followed with the Commission before, and now we have sat down with the Commission and set up a new process to make sure that there are no surprises going forward.
Sorry,
Yes.
MP Ellis, your time is up. Now to the Liberal Party, we're going to go with MP Chang. Go ahead, you have 5 minutes.
Thank you so much. Good morning, everybody. Thank you to the witnesses for taking your time to be here with us today. My question is directed to Deputy Minister of Justice. Is it true that some documents, such as handwritten notes, take longer to review because they cannot be machine read in any way and require a person to directly review the handwritten documents? And could this have affected the disclosure of documents to the Mass Casualty Commission?
Yes, handwritten notes do take longer to review because they have to be reviewed in person. They can't be machine read. Most of the other documents that we get them electronically, so we have a system that reads them and codes them. And that obviously has an impact on the speed with which we can get documents to the Commission. But in this case, the handwritten notes were identified as some important information that the Commission needed to have, which is why we produced them as soon as we could. And they were going to, the ones that we didn't produce and were being reviewed were going to be redacted, reviewed and redacted if necessary, and produced well before the appearance of the officers before the committee, before the Commission.
Thank you so much, Deputy Minister. Can you elaborate on the relationship between your department and the Minister's office? And how do you coordinate with the Minister's office, and what boundaries are in place to prevent any sort of political interference?
Well, I'm the Deputy Minister to the Minister of Justice. We have the same relationship that any Deputy Minister has to a Minister of the Crown. I provide the Minister with information, with briefing notes to make decisions. If I think ever that there was some political interference in a matter where there shouldn't be, I would raise it with the Minister and have a discussion with him. But as I said earlier, the Minister of Justice and his entire office had no involvement whatsoever in the department's job to review and produce documents before the Commission in Nova Scotia. So in this case, sir, they'd have no involvement whatsoever.
So there are guardrails in place to stop any political interference. There are specific guardrails, or it's just an unwritten rule?
There's no buzzer or anything like that would, or specific guardrails. If there's, and we have to look at that in our department because the minister is the minister for more than, he's accountable for the Department of Justice, but other agencies as well, including the Public Prosecution Service, where there's a clear legislative independence there. So we have processes in place to make sure that information that the Attorney General gets from the PPSC, for example, follow what's called the Section 13 process. So, but in this case, our Minister's office had no involvement. And if I thought that there was some interference, I would flag that issue with the Minister and have a discussion with him.
Thank you so much. Can you discuss the steps that legal counsel takes to review documents and ensure non-partisanship in their decision to release these documents to the public?
Did you want to take that? Oh.
Sure. So once documents are produced by the originating department, our counsel and paralegals review those documents for relevance. They also review them for any legal privileges that may attach to them. They are then produced to the Commission, and there's ongoing productions over the course of the inquiry, both in terms of the timetable and priorities set by the Commission, and in response to specific requests by the Commission and questions that may arise in the course of interviews or at the hearing. And,
Thank you so much. Did you want to elaborate on that? I'm sorry, I cut you off. Will you elaborate?
Sorry, sir, you had a second part to your question, which I didn't quite hear.
Oh, no. So, yes. So, is there a non-partisanship in the decision to release these documents?
These are decisions that are taken by the litigation team working on the inquiry. These are not decisions taken at the political level.
Thank you so much. I will return the rest of my time to the chair.
Thank you, MP Chang. Maintenant, le Bloc québécois.
Now we'll go to the Bloc québécois. Ms. Normandin. Thank you very much. I'd like to come back to what Mr. Rees was explaining. He said the production of documents can be done automatically by Justice Canada, or could be subject to subpoenas. And we've understood that there are 39 subpoenas issued. Now, the document package that included those 4 pages, do you know if they were supposed to be produced automatically, or were they subject to subpoena? Unfortunately, I do not recollect. My impression is that they were requested by the Commission. Thank you very much. Now, there was a period of around 3 months from the time when the notes were analyzed to the time that they were produced. Can we get some assurance that the Commission would not be able to conclude its mandate as long as there were outstanding documents still being analyzed for redaction. Is that something that could potentially happen? And depending on the answer, how can we make sure that we don't have a situation where some documents are not produced? Between our team in Halifax and the lawyers of the Commission, there's a good dialogue. And if the Commission says that, we're going to conclude at the end of August, for example, well, we need to ensure that we need to have that category of documents ready and produced by that date. So there's an ongoing discussion between the two teams of lawyers to ensure that the Commission has everything it needs from the government to be able to carry out its work. Perfect. So essentially it would basically be impossible for the Commission to conclude its work and to still have outstanding documents that were not produced. If we think that we have documents that are still relevant and that are still being analyzed, we would inform the Commission of that. If the Commission says, we're wrapping up in 3 weeks, we would say there are still documents that we need to produce. Perfect. Thank you, Madam Chair. I don't think I have enough time for another question, so thank you very much to both of you.
See, Deputy.
Thank you.
And now we're going to go to the NDP. Ms. MP McGregor, you have 2.5 minutes.
Thank you, Madam Chair. My question is very much related to the last one. Deputy Minister, at the end of page 5 of the letter that you provided to the committee, you do say that the Department of Justice recognizes that those 35 pages that were retained for further review was an error. You also went on to say that Justice Council have explained how the oversight occurred. You've provided a full accounting for those 35 pages, and that you're also engaged in extensive discussions with MCC Council regarding the document production process. So I know you've touched on this a little bit, but on the term extensive discussions, I guess what our committee would like to know is what tangible processes are now in place to ensure these oversights don't occur any further. Could you just elaborate a little bit on what's changed within the Department of Justice to ensure that these aren't going to be happening in the future?
And there's an exchange of correspondence between Mr. Cromwell and Ms. Ward on exactly that, and I'm happy to share those letters with the committee so that it's clear for everybody. The Commission suggested that that if we could provide a list of the Government of Canada numbers for documents containing additional pages, and that if there's future disclosure of the additional pages contemplated in the letter, we would identify that using those numbers. So we've written back to Mr. Cromwell to explain to him exactly how that process should have applied and what the government numbers are. So going forward, we do have a process, and I'm happy to share those 4 letters that explains that to the committee.
If you can table that with our committee, that would be appreciated. And Madam Chair, that concludes my questions. Thank you.
Thank you, MP McGregor. Now we're going to go to the last round, beginning with the Conservatives. MP Lloyd, you have 5 minutes.
Thank you, Madam Chair. And thank you to the witnesses. Earlier on today in your testimony, my video is turned off. Early on in your testimony today, you stated that you didn't see any problem with Superintendent Leather releasing information about the April 28th call because that was already in the public domain. Is that correct?
It's relevant to that at the commission, yes. So I didn't I wouldn't understand why Superintendent Leather would say that we advised him that he couldn't talk about that when those documents were already public. In fact, we were all talking about that. That was part of what this committee heard and what the commission heard as well.
And you also said that you were not aware of the April 22nd call that Superintendent Leather had with Commissioner Lucky until he spoke about it at the inquiry, correct?
That's correct. So I heard him mention that, I think at this committee on the 25th, but our council who are working in Halifax on the team were in hearing that day, didn't hear it, but they heard it from him when he testified at the commission on the 27th. in 2022.
Okay, so you didn't hear about it on the call that your officials did not hear about the 22nd call with Commissioner Leckie and Leather when he spoke with the Justice Department.
July 5th, when our council met with him, he raised it for the very first time when he testified before this committee.
I find this very interesting because in a CBC interview, Leather stated that did he reach out to the department? He reached out to you seeking legal advice, correct?
With every witness to prepare them, to help them prepare for their testimony. So it's part of the services that we provide as the Department of Justice, is to prepare the RCMP and other departments for their testimony before the commission.
So Superintendent Leather stated in an interview with CBC that he specifically raised the issue of the April 22nd call with the Justice Department because he was concerned about the relevance of that in regards to the later April 28th meeting. So are you saying that Superintendent Leather basically just imagined that he brought up the April 22nd call to your officials?
Met with him on the 5th. They tell me that he did not raise it. It is not in the notes that he's submitted as part of the 2,400 pages of notes. Nothing in his notes mentions this call to the commissioner on the 22nd. And during his testimony, our council were surprised to hear for the first time that there had been a call on the 22nd, because it had never been mentioned before he testified on the 27th.
I just think it's very interesting because Superintendent Leather stated that that was the whole purpose that he wanted to talk to the Department of Justice, was about that April 22nd call. So if that was the whole purpose of the meeting, he didn't mention it was about a wellness report. He mentioned it was about the April 22nd call and what he could and could not share. And so the main reason that he reached out to you guys was about the April 22nd meeting, but you're saying that you don't have any evidence that he brought it up at the meeting.
Our council are telling me he did not bring it up at the meeting, and he didn't reach out for us to talk about the April 22nd call. He met with council in order to be prepared on his entire testimony, not just the question of the April 28th meeting or the meeting of the call of the 22nd. He didn't raise that, and there's nothing in his notes for us to have raised it with him either. We didn't know that there was that call. We learned about it for the first time when we met with him when he testified about the call on the 22nd at his testimony before this committee and then the commission 2 days later. The wellness report, either because it was commissioned a year after the events by, I'm not sure by whom, but by the RCMP, he raised it for the first time on July 5th. We had never heard of it. And so,
Have you had time to review this wellness report now that you bring it up?
I have not reviewed it myself, no, but our council have. And
does the Department of Justice
version,
consider that is privileged at this time?
We have produced a copy of the report for the commission. The commission has not yet decided whether to make it public in part or in whole.
Is it redacted in any way?
It is redacted for personal information, is my understanding, but I haven't seen it myself.
And is your department responsible for the redactions on Leah Scanlon's testimony that we've seen the commission release?
You have time to respond, and then we have to wrap up.
I'm not sure which redactions you're referring to, so I'm afraid I don't know the answer.
Yeah.
Thank you.
Thank you, MP Lloyd. We're going to have to move on to Liberal Party. MP McKinnon, you have 5 minutes.
Chair, thank you. I'm going to actually take MP McKinnon's time.
Okay.
Thank you very much. Deputy Minister, just a few questions because I think we've gone over this quite extensively. Can you just confirm that the Minister of Justice in his office had no awareness had no involvement, in the decision to retain the 35 pages of senior officer notes, including those of Superintendent Campbell? I'm sorry, I can't. Oh, okay.
That is correct. They've had no involvement in the decision to disclose the 2,400 pages or to flag the 35 pages for review. In fact, they've had no involvement in any of the productions of the 75,000 documents that have been produced so far.
Okay, thank you. And then in terms of determination of relevance and privilege and redactions, those are made strictly by justice lawyers and paralegals in consultation with relevant departments and agencies, and the Minister of Justice and his office are not involved in these decisions?
That's correct.
Thank you. And then finally, Deputy Minister, you provided the committee with a 6-page letter, and I thank you for doing that. Is there anything that you provided in that letter? You only had 5 minutes for opening, and I know you've been testifying for an hour, but was there anything in that letter which you have not had an opportunity to speak to that you'd like to now?
I don't think so, but I'll just quickly go through it. I think we've covered everything that's in the letter. No, I think nothing else. Thank you.
You're welcome. And that letter is public, so if anyone watching this on is able to access that letter that you provided us for more information. And I think based on your testimony, Deputy Minister, it's pretty clear that the Minister of Justice and his staff had no involvement in decisions that were made in terms of what was turned over to the Mass Casualty Commission. So, Chair, I think I imagine we want to take a short break while we change panels, so I'll turn the rest of my time back to you.
MP Damoff, and you are correct. We will suspend the meeting while we turn it over. Thank you to the witnesses for being here today. Thank you very much. Thank you to the witnesses for being here today. I'm normally the vice chair of this meeting, and I'm assuming the chair position today. My name is Raquel Dancho. Oh, do I have to read these all again? No, okay. Just a reminder to the committee members to keep your mic on mute when you are not speaking. And we are going to begin, I'm going to begin the first round of questioning myself, and then we're going to go to the other parties. Oh, I'm so sorry. You have opening statements, so we're going to go to those first. We'll start, just start from left to right. Yeah. We'll start with you, Miss. We'd like you to start. 5 minutes, please. Go ahead.
Today before the committee on the traditional territory of the Algonquin people. Before I begin, I would first like to express my sincere condolences to all of those who lost loved ones, neighbors, community members, and those that were hurt in Nova Scotia on April 18th, 19th of 2020. My name is Alison Whalen. I am Chief Strategic Policy and External Relations Officer for the RCMP, based at national headquarters in Ottawa. I have held this position since July 2020. During the time period being examined by this committee, I was the Executive Director, National Security and Protective Policing, which is situated within the Federal Policing business line at RCMP National Headquarters. Given my position at the time period in question, I was neither aware of nor involved in the internal RCMP meeting on April 28th, 2020, nor was I engaged in the requests or sharing of information with government officials or communications with the public during the spring of 2020. That said, of course, I'm happy to answer any questions you may have. Thank you.
Thank you. It was Ms. Whelan, correct? Apologies to the members. We don't have the name cards, unfortunately, today. Thank you, Ms. Whelan. Mr. Campbell, you have 5 minutes.
Thank you, Chair and members of the committee. My name is Darren Campbell, and I'm a serving member of the RCMP. My policing career began in September of 1990 when I was sworn into the RCMP. On that day, I swore that I would faithfully, diligently, and impartially execute and perform my duties, and to obey and perform all lawful orders that I receive without fear, favor, or affection of or towards any person. That was an oath I took very seriously on that day, and one that I continue to take very seriously to this day. My 32-year career with the RCMP has taken me from the Pacific Coast to central Canada and to the Maritime provinces. The bulk of my career has been focused in the area of major crimes, major case investigations, and criminal operations. As part of my duties, I've been operationally deployed across our entire country and internationally. I'm committed to serving Canadians, the communities that I have served and continue to serve. I'm a proud member of the RCMP, and at the present time, I am the interim criminal operations officer for the RCMP in the province of New Brunswick. In April of 2020, I held the rank of superintendent. I was a support services officer for the RCMP in Nova Scotia. In that role, I was responsible for a number of specialized policing resources, including but not limited to the Provincial Major Crimes Unit and the Critical Incident Program. As you are well aware, on April 18th and 19th, 2020, the RCMP in Nova Scotia responded to a mass casualty incident where Gabriel Wortman took the lives of 22 innocent people, and he injured many others. This incident became known as the worst mass murder in Canadian history. The perpetrator's actions devastated victim families, survivors, and has forever changed the lives of many. This unprecedented massacre spurred a major case investigation titled Operation H-Strong. The objectives of H-Strong were clear: to fully investigate the murders and attempted murders and to gather sufficient evidence to determine Gabriel Wortman's involvement in these horrible crimes. Further, the objectives also set out to determine if anyone had assisted Gabriel Wortman in any way before, during, or after the crimes, and if so, to gather sufficient evidence to successfully prosecute those believed to be involved. I am aware of certain allegations of political interference directed to the RCMP with respect to the investigation into the mass casualty incident. At the heart of the issue is my recollection of a meeting that I was called to attend on April 28th, 2020. This meeting took place immediately after I completed a lengthy national press conference which relayed the facts that could be disclosed to the public at that time. To that point, I had provided more than 2 hours and 15 minutes of live national news conferences about what the police knew and what we could share with the media and with the public. The meeting had been called by the Commissioner of the RCMP and was attended by representatives from the RCMP in Ottawa as well as Nova Scotia. Prior to that meeting, I did not specifically know why the meeting had been called. However, once the call commenced, the purpose of the call became very clear. The Commissioner expressed in no uncertain terms her clear disappointment that I did not release specific information in my news conference related to the firearms used by the gunman. What was relayed to me and others during that call is at issue here today. I made notes, as is my practice, specific to that meeting. I advised several of my colleagues that I had made notes about what had transpired in that meeting. I disclosed all of my notes as required to the Department of Justice Canada for dissemination to the Mass Casualty Commission. I was not aware that my notes from April 28, 2020 had not been disclosed to the Mass Casualty Commission until recently. I stand by the notes that I made on April 28, 2020. I have a distinct recollection of the content of that discussion between the Commissioner, my colleagues, and I. In my view, the purpose of the call was to allow the Commissioner to express her disappointment with the fact that I did not relay specific or detailed information about the firearms used by Gabriel Wortman. On several occasions during that call, the Commissioner stated that she felt disrespected, that she was sad and disappointed with the fact that I had not released the information about the firearms used, and that she had been advised that I would release that information. The Commissioner also said that she had promised the Minister and the Prime Minister's office that information about the firearms would be included in the press briefing. As detailed in my notes, I attempted to explain to the Commissioner that I could not and would not release that information at that time, as a premature release could have a negative impact on the investigation. It was at that time the Commissioner told my colleagues and I that we didn't understand, that this was tied to pending legislation that would make officers and the public safer. I left that meeting feeling deflated, and to borrow the Commissioner's words, sad and disappointed. My position was firm that I would continue to protect the integrity of the investigation by not releasing any information that could have a negative impact on ongoing investigative efforts. We owed this to the victim families, the survivors, to the public, and to those tasked with completing an impartial, competent, and professional investigation. There are very good reasons for that. The approach to not releasing specific information related to the firearms remained in place by the investigative team until information related to the firearms used by Gabriel Wortman was released in November 2020 through an access to information and privacy request directed at the Prime Minister's office, not the RCMP. Within the disclosure of that information via ATIP was specific information related to the firearms used by Gabriel Wortman in the commission of the offences. The release of the unedited information would eventually have a negative impact on individuals and could have harmed the ongoing multi-agency investigation. So in summary, it was never my intention to enter into a political or public disagreement or discussion as to what took place in that meeting, nor was my response to the meeting based on any personal issues with the Commissioner or indeed any other individuals, nor was it based on politics. At the heart of the issue was a matter of principle and sound investigative best practices related to protecting the ongoing investigation, which at the time was in its early stages. The principle was the oath that I swore to uphold as a young recruit over 3 decades ago. I could not and would not break that oath, which is sworn by all members of the RCMP. Chair, this concludes my opening remarks, and I wish to thank you and the committee for the opportunity to speak with you today. I welcome any questions that committee members may have on the issue.
Thank you, Mr. Campbell. Ms. Scanlon, you have 5 minutes.
Thank you. Good afternoon, Ms. Chairman, honorable members of the committee, and my colleagues. My name is Leah Scanlon. I'm a 14-year civilian member of the RCMP, and as of January 2022, my position is that of Strategic Advisor to the Commanding Officer of Nova Scotia. In 2020, I was the Director of the Strategic Communications Unit for the Nova Scotia RCMP. Before I go any further, it's important to acknowledge at the outset that we must maintain sight of what took place in Nova Scotia on April 18th and 19th of 2020. The worst mass casualty in our country's history. 22 people lost their lives, including a colleague. None of us will ever understand what the victims and their families have experienced and continue to go through. Honoring the victims' lives and keeping their children and families at the forefront is what's most important. Countless others are injured physically and mentally, and they must remain in our thoughts as they face a lifetime of healing. What took place forever changed Nova Scotia. It has been indescribable and far-reaching. The strength and resilience of our Nova Scotia communities has been obvious for all to see in the aftermath of this tragedy. People have rallied together in countless ways, a demonstration of the true maritime spirit, and it makes me very proud to call myself a Nova Scotian. The tragedy of April 2020 and its aftermath has been a very challenging 2.5 years professionally and personally. On April 19th, 2020, I was involved in the operational response. The Provincial Strategic Communications Unit led the communications during the incident in the weeks and months following until the completion of the investigation in December of 2020. Our focus centered on the victims and the families, the public, and our people. I have participated in and respect the work underway by the Mass Casualty Commission, having engaged honestly and wholeheartedly in 2 separate interviews, and again on June 9th of this year at my appearance in the inquiry. I also respect the work of the Standing Committee on Public Safety and National Security, and I'm here in person, prepared to answer questions in relation to my experience. Specifically the following: a phone call and email correspondence hours before the press conference on April 28th, 2020, a phone call I received after the press conference, and a subsequent meeting I attended called by Deputy Brennan on behalf of Commissioner Lucky on the evening of April 28th, 2020. A letter I wrote to Commissioner Lucky on April 14th, 2021, within days of the 1-year anniversary of the tragedy, and any other relevant emails or notes I have, as I've taken much time reviewing the material produced during this period. I look forward to answering your questions. Thank you very much for having me. Thank you.
Thank you, Ms. Ganlin. And over to you, Miss. Please go ahead, Ms.
Thank
Bradley.
you, Madam Chair, and good afternoon, members of the committee. My name is Jolene Bradley. I'm currently the Director General of Communications at the Royal Canadian Mounted Police here in Ottawa. I appreciate the opportunity to speak with you today on my role during the largest mass shooting incident in our country's history. It was a very difficult time. My thoughts and prayers continue to be with the families and friends of loved ones who are left behind trying to heal. In April 2020, I was the RCMP's Director of Strategic Communications for the operations team at National Headquarters in Ottawa. I provided strategic communication advice and support to the communications team in Nova Scotia in the days and weeks following the shooting. As part of the ongoing and routine collaboration between National Headquarters and our colleagues in Nova Scotia, our support included reviewing speaking notes and messaging for media. My goal was to assist our colleagues in Nova Scotia during such a significant event. Our support from Ottawa also consisted of coordinating translation and assisting with the creation of visuals for the press conference. I was also responsible for ensuring communications products such as talking points and media lines were shared with communications colleagues at Public Safety Canada, as well as the RCMP's analyst at the Privy Council office. This is standard operating procedure and our communication colleagues with both organizations. To be clear, documents shared with Public Safety and PCO were final communication products such as speaking notes intended for delivery by RCMP spokespeople during the conferences. Operational information is never shared through communications channels. I also want to emphasize that material is shared for informational purposes only, not for comment or input as it related to an ongoing investigation. The lines are clear and reinforced through years of collective experiences. Chair, member of the committee, I have worked for the RCMP for 23 years in various communications positions. Managing the communications and public affairs around the shooting was very difficult and very demanding. I would like to commend the RCMP team in Nova Scotia for their steadfast commitment to the organization and desire to share as much information with the public as was possible at the time. We are lucky to have such talent in Nova Scotia and, quite frankly, in all communication shops across the country supporting the RCMP on a daily basis. Thank you. Merci.
Very much for your opening remarks to you and to all the witnesses today. We're going to get started with the round of questioning. I will begin with 6 minutes, and we go to the Liberal Party, then the Bloc Québécois, then the NTP, and back around again. So to begin, Mr. Superintendent Campbell, have you received any legal advice from the Department of Justice to answer our questions or the questions of the Commission reactively rather than proactively, as Mr. Leather has indicated that he received that information, that advice? You have not. Thank you very much. And I'm looking at an email dated April 23rd sent by Commissioner Lucky to Chris Leather, Lee Bergerman, and Brian Brennan, in which the Commissioner said in her email that the Government of Canada and the Minister of Public Safety were anxiously awaiting the information about the weapons involved in the mass murder. Were you aware that the Government and the Public Safety Minister were anxiously awaiting this information?
At that time, Chair, I wasn't aware that the government was anxiously awaiting. I wasn't part of that email chain. However, I was aware of the fact that the Commissioner's office was really looking for some detailed information specific to the firearms.
Thank you. And you had mentioned in your opening remarks that you believed releasing the information was, quote, premature to release and would have had a negative impact on the investigation, correct?
Yes, that is correct.
At this point in the investigation, this was only a few days after the incident had happened in Nova Scotia.
Not only, Chair, was it only a few days after the incident had happened, but there were several other agencies, including the Canada Border Services Agency, as well as the FBI and the ATF, who were conducting parallel investigations to our investigation as well. So it would have had a negative impact, definitely.
Thank you. Thank you very much. On the same day that Commissioner Lucky mentioned in an email that was April 23rd that the government and the public safety minister were anxiously awaiting this information, there was consultations with the Serious Incident Response Team, which you know is essentially an oversight body for the Nova Scotia RCMP, had advised Lee Bergerman, which he said in an email to Chris Leather, Brian Brennan, and Commissioner Lucky that, quote, we have permission to release the information about weapons internally. Were you aware of this email in which Commissioner Lucky was advised the information should only be released internally?
I wasn't aware of that specific email, Chair. However, I was aware of the CERT investigation and the sensitivities in and around what they would wish to protect related to the firearms. I had awareness of that.
Mm-hmm. So Ms. Bergerman was advising Commissioner Lucky that this was to be released internally. And then within half an hour, the Commissioner released that information outside of the RCMP. She sent it to the Minister of Public Safety and also the National Security Advisor to the Prime Minister. Were you aware of that?
I'm now aware of that, Chair. However, at that time, I wasn't aware that it was released outside of the RCMP.
Do you believe it was appropriate for the Commissioner to release this information at that time to the Minister of Public Safety?
I don't believe that it was appropriate at that time. However, I do expect that there would be conversations. But from my understanding, the direction was fairly clear that it could not be shared outside of the RCMP.
Thank you. You'd mentioned in your commission testimony that you decided to make the notes on April 28th because, quote, it was going to become a problem for us, referring to the April 28th meeting, the infamous meeting. What specifically seemed inappropriate about the Commissioner's remarks or conduct that sort of sent off these sort of alarm bells in your mind?
Well, Chair, as I mentioned, there were investigative objectives which included the investigation of any other individuals who may have assisted Gabriel Wortman in any way. The release of that information would have a negative impact on the ongoing investigation outside of the investigation into Gabriel Wortman's activities.
You had wrote with your notes, as we know, that the Commissioner said she had promised the Minister of Public Safety and the Prime Minister's office that this information would be released. Did she say promise?
I believe that she did say promise, yes.
And you went on to write that the Commissioner said that you didn't understand, you mentioned this in your opening remarks as well, that this was tied to the pending gun control legislation. So she was specifically tying this to the government's legislative agenda. Is that correct?
Yes, that's correct.
So she went against expert advice. She's also been a member of the RCMP for 30 years. She was aware that this was not to be released outside of the RCMP. She did release it to the government. Is that my understanding is correct? Is that correct?
Well, as I understand it now, it was released outside of the RCMP2 government, which was contrary to the directions that were provided.
And specifically, it was related to the pending gun control agenda of the government.
Well,
is
Chair,
what she said in the
I
meeting.
can't speak to that because I was never part of any of those conversations between government and the Commissioner's office.
Mm-hmm. But in the April 28th meeting, she related those two. She tied them together.
That is correct.
And she made that very clear?
It was clear to me.
She made when the Commissioner attended the committee a few weeks ago, she made it seem that meeting was not so much about specifically this issue. It was just generally about an unhappiness of communication with the Nova Scotia RCMP. How much of this meeting was about this gun control legislation and releasing the weapons information versus other things?
Chair, if you refer to my notes, they also explain that I left the meeting at one point in time. I would say I was probably in that meeting for around a 20-minute period of time. The information during the period of time that I was actually in that meeting was only specific to the non-release of the firearms information. It did not include any other information related to any displeasure that the Commissioner had in terms of our communications. In fact, I would even say that I have emails from the Commissioner recognizing the efforts that I had specifically made on April 24th, where she references the Minister of Public Safety wanting to express his thanks for the information that I had provided to the public.
Would you be willing to table those for the committee and provide those emails to the committee?
Yes, I will.
Thank you very much. With my remaining 30 seconds, Ms. Scanlon, who are you speaking with in the government, Public Safety Minister's office, Prime Minister's office? Can you provide the names of the individuals you were speaking with?
I wasn't speaking with anyone in those offices.
Ms. Bradley, were you speaking with anyone in the Public Safety Minister's office, the Prime Minister's office? What were the names of those individuals?
I had no connection with anyone in the Minister's office or in the Prime Minister's office.
So who was the connection between Nova Scotia and the Public Safety Minister's office? Was that solely Commissioner Lucky then, to your knowledge? Ms. Whelan, if you have anything to add.
No, sorry, I wasn't a party to those interactions.
Okay, thank you very much. And that concludes my time. Thank you very much for your comments. And we're going to go over now to the Liberal Party for the opening remarks. We have Ms. Damoff. You have 6 minutes. Please go ahead, Ms. Damoff.
Thank you. And I will start by, again, expressing my deepest sympathy to the families of the Nova Scotia families of the shooting. And I also want to thank the witnesses that are here today and recognize that this is very difficult for each of you and that it can be very triggering to be reliving what happened before us. So I want to sincerely thank each and every one of you for being here today. Superintendent Campbell, you mentioned in your remarks that you were not part of any conversations with the government. Can you just clarify for us that you did not have any conversations with the Prime Minister, the Prime Minister's office, Minister Blair, or his staff?
That's correct, Chair. I did not have any direct conversations with anyone from government on this issue.
And I thank you. And I believe, or I imagine that you've seen the testimony from both Minister Blair and Commissioner Lucky. Minister Blair indicated that he did not ask the commissioner to make any promises in terms of releasing the weapons that were used. And Commissioner Lucky was also very clear that she had not made any promises to the government. So would it be fair to say that you've heard their testimony when they appeared before us in July, that your interpretation was different than the commissioner's, Superintendent Campbell?
Well, just to be clear, I haven't actually watched the entire testimony of the minister or the commissioner prior to this. What I can say is that my recollection of the meeting that I had with the commissioner is reflected accurately within the notes that I made and the testimony that I provided at both the Mass Casualty Commission under oath, as well as appearing before this committee.
Okay, thank you. So Minister Blair said, quote, "I did not ask the commissioner to release that information, nor did she promise me that she would." And then the commissioner said, regarding my use, again, a quote of the word promise during the meeting, "I had my team following the press conference at that time. And in that context, I was trying to convey that I had confirmed to the minister that the information about the weapons would be released during the press conference, confirmation that had been made based on information that I had been provided." One of the things that I was a little curious about, we heard testimony from Lee Bergerman, and again, I'll quote, "It should never have been shared with her being the commissioner, that we were going to release details of weapons and calibers or whatever." I'm curious, Superintendent Campbell, why would the commissioner not have been given that information? Why should that not have been shared with her?
I think what Assistant Commissioner Bergerman was referring to is that any promise being made to the commissioner that we would release that information. That's how I interpret that passage from her testimony. It wouldn't necessarily be about not wanting to release information about the guns to the commissioner to stay within the organization. It was about making a promise to release it publicly. That's how I interpret that. And that should not have happened.
Okay, that wasn't my recollection of her testimony, but we'll leave that as it was. When was the information released to the public about the weapons, and how did that become public?
Referred to in my opening remarks, it was in November, I think November 20th of 2020, that the information was released not by the RCMP, but actually via an ATIP request to the Prime Minister's office. And I would assume that it was a briefing note that was prepared for the Minister's office or the Prime Minister's office, which outlined the details on the guns, as well as the names or one name of one of our officers that was actually involved in the fatal officer-involved shooting of Gabriel Wortman.
But it was never released by the government or the RCMP commissioner or yourselves. It was only released as a result of the access to information request, correct?
That is correct.
Okay, thank you. In terms of your interactions with the commissioner and the commissioner with the government, it is her, she's the head of the RCMP. At the end of the day, she makes the decision what she shares with the government of Canada. We were all at that time, COVID had just started. I think the entire country was in shock. You testified that you had just been through 2 hours of a press conference, which must have been absolutely grueling for you, sir. I can't imagine how difficult that was. Would it not be fair to say that tensions were probably a bit high between Nova Scotia, within I guess that's not the right term. That it was very emotional for everyone at that time and during that phone conversation?
I would agree that the emotions were high during the incident, and to this day they continue to be high. And that was reflected within that conversation as well on April 28th.
Okay. I only have 10 seconds left, Chair, so I will turn it back to you. Thank you very much for your testimony, sir.
Thank you, MP Damoff. And we're going to go now to the Bloc Québécois. Député Normandin.
Ms. Normandin, you have 6 minutes. Thank you very much, Madam Chair. I'd like to start by thanking the witnesses, not only for being here today, but also for the quality of their opening remarks. Mr. Campbell, I'd like to start with a question to you. And I just want to mention something that I think everyone should be keeping in mind during their answers. And that is that the press release that Commissioner Lucky issued in June 2022, she said that she would never take any steps or make any decisions that might compromise an inquiry. So if we go back in time to the conversation that you had on April 28th, Mr. Campbell, at that time, did you have the impression that the commissioner understood the scope of what she was asking, that she understood the scope of the risk of what she was asking? Did she understand, do you think, that communicating the type of firearm used might compromise the inquiry?
So thank you for your question. I do believe that the commissioner, as a seasoned police officer, would understand that certain information should be protected, particularly if there are multiple agency ongoing investigations. So I can't speak for the commissioner. However, I think that it's reasonable for me to answer that question in that way.
Yeah.
And at the time of this discussion on April 28th, you yourself raised the question of, or the issue that this might cause the inquiry to be compromised. Is that correct?
I did in terms of not just the investigation that was being handled by the RCMP at that time, but also, as I stated earlier, multiple investigations by multiple agencies, including international agencies as well. That was made clear to the commissioner. That was made clear to my colleagues. I had been asked, in fact, leading up to that press conference by my colleagues within Strategic Communications in Nova Scotia if I could say more about the firearms. And I explained to my colleagues in Nova Scotia the reason why I could not. And that was clearly communicated to everyone. And it was actually quite simple.
Est-ce que vous pourriez me
Could you describe the way Commissioner Lucky reacted when you talked to her about how important it was not to communicate that information?
Well, Chair, as I explained in my opening remarks, the Commissioner was upset. The Commissioner made me feel as if I was stupid and I didn't seem to understand the importance of why this information was important to go out, the information specific to the firearms as it was related to the legislation. She didn't seem to appreciate or recognize the importance of maintaining the integrity of an investigation.
Est-ce que vous pourriez me
Could you tell me around how long that part of the discussion lasted? Like the part of the discussion that was specifically about the risk of compromising the inquiry?
Well, of course, I'm going back more than 2 years since that conversation took place. But I would say that my comments to the commissioner and others that were in that meeting probably lasted at least 2 minutes of me trying to explain. And it was on the heels of that explanation is where I was provided information, or I was told that this was very important because this was about legislation that was going to make officers and the public safer. That was the response I received to my rationale provided for not releasing the information.
At any point, did Commissioner Lucky try to refute your arguments? You know, when you were arguing that this would pose a risk to the inquiry? Did she try to convince you that there was no risk? Or did she simply want the information to be revealed for other reasons?
My recollection is that the commissioner did not dismiss what I had said in those terms, meaning that she didn't believe that it would have a negative impact or try to provide a different perspective. She immediately linked it to ongoing efforts to bring forward some new legislation.
Donc, je comprends.
So, to summarize, the conversation about the risk of talking about the specific firearms used, that was actually a fairly short conversation, and the commissioner did not try to refute your argument, but it seemed to her that this issue of risk didn't seem relevant to her. Did I summarize that correctly, in your opinion?
From my opinion, I would say that the commissioner felt that the release of the information was more important in her view, because the focus of that discussion was in and around the fact that I did not release that information specific to the firearms.
Je vous remercie.
Thank you very much, Madam Chair. I think that's all the time that I had. So thank you again to all of the witnesses.
Deputy Normandin. Now we have the New Democratic Party, MP McGregor, for 6 minutes. Please go ahead, Mr. McGregor.
Thank you very much, Madam Chair. And I'd like to echo my colleagues in thanking all of the witnesses for being before our committee and helping guide us through this inquiry of ours. Chief Superintendent Campbell, I'd like to start with you. Can you just reiterate for the committee, how long has it been a practice of yours within the RCMP to use handwritten notes?
I've used handwritten notes from the time I was a young recruit in Regina, which would have been in 1990.
And you stated quite clearly that you stand by your notes. I would say the same with my notes. I frequently use them for committee hearings like the one that we're having today. Could you also explain to the committee when members of the RCMP are using handwritten notes, what's the process whereby they are logged? Like, do they go into an official logbook? How are those records kept? Are there some examples where there are personal handwritten notes only for the officer in question's recollection, or are they logged with the detachment? I just want to know a little bit more about that process.
Okay, thanks for your question, Chair. Notes are used by all police officers. They are not the property of the officer. They are the property of the RCMP. And those notes are disclosable for any type of inquiry or investigation, any kind of legal proceedings. Those notes can be produced at any time. They are kept specific to those officers. They are not logged into a general notebook. Each officer would keep a notebook of their own. And specifically, my practice would be normally for a larger investigation to keep a separate notebook on that investigation itself.
And to be clear, when you wrote the notes of the April 28th conference call, this was simply a normal course of your duties, something you've done since you were an RCMP recruit, and you really had no idea that the notes from that time would result in what all of Canada knows today.
Particularly in relation to where I find myself today. However, I was concerned about what transpired during that meeting in April 28th of 2020. I did make notes that reflect my recollection specifically of that meeting. And I also, as I testified earlier, I also was fully aware that those notes would become disclosable. And that could become an issue at some point in time during a multitude of proceedings like this or the Mass Casualty Commission or other criminal trials that were related to this investigation.
Thank you for clarifying that. In the previous meeting that our committee held at the end of July, we did hear from a number of witnesses, and the minister, the previous Minister of Public Safety, the Honorable Bill Blair, he was very clear to point out that, there's a hard line that he's never crossed in terms of giving operational directives to the RCMP. But I think there might be some confusion over whether this was an operational directive or a communication directive. In your view, was this, could you help clarify what your interpretation was during that conference call, or was it a little bit of both?
Question, I do believe that it was a bit of both. Any release of information that could have a negative or detrimental impact on an investigation falls into the operational side. But I also believe that there was a potential benefit to releasing this information. So that's on the communication side. So to answer your question, I would say it is both.
Thank you. And when Commissioner Lucky stated on the call that this was tied to pending gun control legislation, I mean, when we now have the benefit of hindsight of knowing that the order in council came in May of 2020, was any clarification given on that particular point on gun control legislation? Like, did anyone ask for further details, or was it just simply announced that it was tied to impending gun control legislation?
Chair, it was an announcement that was made, and quite frankly, I didn't want to hear anything more about it, and I didn't ask.
And that was the reaction around the room? Like, was there a similar reaction around the room with other participants in the conference call?
Well, I can speak to my observations of the reactions of others in the room, and one of my colleagues is here with me today, Leah Scanlon. Perhaps she can answer your question as well, but I would say that my perception is that the reactions were fairly consistent for those that were in the room with me.
And finally, Chief Superintendent, because our committee is at a crossroads. We have, as you know now, very wildly different interpretations of the same conference call. I'm trying to look forward to the future, and when you look at the federal statute that governs the RCMP, specifically Section 5.1 that really describes the role of the commissioner, there are some who say that that clause is sufficiently vague enough so that there can be very different interpretations of what direction the minister is able to have on the commissioner. Do you have any suggestions on how we as legislators can tackle this issue going forward?
Well, I think it's simple. I don't necessarily want to get into a policy debate specifically. However, allowing the police a level of independence, and that includes the commissioner of the RCMP and those that work within the organization and for the commissioner, respecting that independence because we do have a job. We take it very seriously. We wish to share information as much as we possibly can. That's always been our practice, although there are many that feel differently about that. There are very good reasons, as I explained, why there's certain information that we don't release.
Unfortunately, I'll have to wrap up.
It's about independence.
Thank you very much. And now we will go back, start the rounds again to the Conservative Party with MP Perkins with 5 minutes. MP Perkins, please begin.
Thank you. Also, I'd like to thank the witnesses, and in particular, the Nova Scotia RCMP officers and civilian employees for doing such an amazing job and having such great integrity for us through this process. My first question is to Superintendent Campbell. My understanding, Minister Blair testified before this committee that on April 23rd, there was a cabinet meeting. We also know from emails that later that day, Commissioner Lucky emailed the Nova Scotia team seeking the list of firearms found in the vehicle and said that the government was anxious for this. We also know that later on that evening, she provided that to a number of civilians, the Chief of Staff, the Minister, and 5 other government officials, none of whom work for the RCMP. My understanding is also that the CERT clearance was to only share that information within the RCMP. Do you have any idea what kind of political pressure the minister was under in order to go around the CERT requirement and provide that information contrary to their directive outside the RCMP?
Was asked what type of pressure the minister was under. Could you just clarify?
No,
that?
sorry, the commissioner.
Well, as I had already testified, I wasn't present or party to those conversations. I don't know how much pressure, if any, was being placed on the commissioner because I wasn't part of that. But I do believe that there was, because of the emotions and the need for answers, there were many people who were asking a number of questions. And I would imagine that would have placed a considerable amount of pressure on the commissioner of the RCMP at that time.
Thank you. Ms. Scanlon, in your testimony, your interviews with the Mass Casualty Commission, you mentioned that you had regular contact with Dan Bryan, who was Media Relations and Issues Management for the RCMP. Is that correct?
That's correct, yes.
And in that statement, you said that Mr. Bryan, he's in one of the statements, he has tons of experience with government and people he knows. He was a connection into the government. Is that correct?
Yes.
Did he ever mention to you in the discussions you had with him, either before the mass casualty incident or afterwards, that he was talking regularly with people in government?
No, he did not.
He did not. So you're not aware that he may have had any discussions directly with the minister's office where he had worked previously to this job in the RCMP?
Correct, I'm not aware of that.
Okay. Ms. Scanlon, in your notes or your letter, you're quite descriptive of your experience with the situation on April 28th. Also, you had mentioned earlier that 2 hours beforehand, I believe, you had been informed that they wanted the details released. Who asked you that question?
Deputy Brennan.
Okay, thank you very much. Is the recollection, obviously, of Superintendent Campbell's notes of that meeting accurate from your perspective?
Absolutely.
Thank you. Did the minister say that she promised the minister that she would provide that information?
I believe you meant the commissioner say?
The commissioner,
yes.
sorry.
Yes. I don't recall verbatim the exact words that were used, but I would never dispute Darren Campbell's notes. And I just think at the end of the day, whether we're saying promise, pressure, influence, they all lead to the same end result.
Thank you. I do have a lot more questions, Madam Chair, but I do have a motion I'd like to move at this time, if I could.
MP Perkins, it's your time, so go ahead.
I would like to put forward that pursuant to Standing Order 1082, the committee hold a 3-hour meeting on the allegations of political interference in the 2020 Nova Scotia mass murder investigation study, including 30 minutes of committee business, no later than September 16th, 2022, to hear from the following witnesses: Zita Astravaz, Chief of Staff to the Minister of Emergency Preparedness; Felix Cachillon, I'm not sure if I'm pronouncing that right, Director of Nova Scotia's Serious Incident Response Team; Ken McKillop, Assistant Secretary to the Cabinet, Communications and Consultations, Privy Council Office; Dan Bryan, Director of Media Relations for the RCMP; Cindy Bayers, Director of Strategic Communications, RCMP; and that the calendars and phone logs from April 18th, 2020 to April 22nd, 2020 of the Minister of Emergency Preparedness and his Deputy Minister and his Chief of Staff be provided prior to the meeting. And I believe that has been provided to the committee for the clerk to circulate.
Thank you, MP Perkins. May I suggest that we pick this up after we have MP Noor Mohammed and also Mr. McGregor and Mr. Normandie have their questions. If it's the will of the committee, we can pick this up at the top of the hour and let our witnesses go following the questions.
That's fine with me.
Any objection from the rest of the committee members to finalize our questions? Oh, Madame Normandie, s'il vous plaît, merci.
Yes, if you'll allow me, Madam Chair. I just wanted to ask that we make sure that the motion is circulated in both official languages so that we can see it.
Merci, Madame.
Thank you, Ms. Normandin.
The motion is being passed around as we speak to the committee members in both languages. Thank you for that question. Mr. McKinnon, you had your hand up, but I see it's been lowered. Do you have anything to say?
I was going to speak to the motion, but if we're going to take it up later, I'll take it up later.
Yes. Okay. So let's get back to our questioning, and we will pick this up at the top of the hour after we let our witnesses go. So we're going over to the Liberal Party with 5 minutes. MP Noor Mohammed, go right ahead.
Thank you very much, Madam Chair. And I wanted to thank the witnesses for being with us today. And I also want to just thank you for the kindness and compassion that all of you have shown, in particular in dealing with the victims and the victims' families. As someone who had the privilege of working as a public servant alongside, in many cases, the RCMP after a tragedy where lives were lost, the work that you do is incredibly important. And I know I can only imagine the toll that it's taken on all of you. So I just want to thank you for what you have done and the work that you have been doing. I wanted to very quickly begin by asking a question. Excuse me, losing my voice. Related to the ATIP process to Ms. Whelan. Can you very quickly explain to us who handles the ATIP process and whether or not political offices can dictate what is and is not released?
Well, in this case, it was an ATIP from the Privy Council office, but just in general, no, the ATIP shop would contact the Office of the Primary Interest. They would identify potential redactions. The ATIP shop would then confirm, and the information is released to the requester.
Thank you. All right. Well, if I could just switch gears a little bit now and start with you, Superintendent Campbell. When you were describing your recollection of the events, you noted that you had never heard from the minister or from any other political office, whether it was the Prime Minister or the Prime Minister's office, a direction to the Commissioner to demand the release or instigate the release of any information, correct?
Not.
And Ms. Scanlon, was it the same in your case?
Correct.
Okay. The Commissioner came before us and testified that she did not experience any political pressure. And the Minister came before us and said that he did not exert any political pressure on the Commissioner to release information, and that she did not promise him that she would. Minister Blair was a long-time police officer. I think he explained to us very, very clearly that he understood the chain of command and the lines that could not be crossed. If the minister's office and the minister and the commissioner have all said that the minister didn't ask for this information, what was prompting this request?
We can just determine who the question is directed towards.
Sorry, that was for you.
Okay, sorry. So could you just repeat the tail end of your question, please?
Yeah. So we had the minister say that he didn't ask for the release of this information, and the commissioner said that she did not feel pressured by the minister or other political offices to do anything. What do you think prompted, or why do you think then there was this sense of pressure?
Well, as I testified earlier, Chair, there was pressure for information from all sides, whether it be the public, the media, government, within the organization itself. But it was clear during that meeting that the commissioner had said that she had made a promise and that it was tied to the legislation. I can't speak to who it was that might have had those conversations. I can only speak to the fact that I was involved in a meeting on April 28th, and that's what I heard, and that's what I made notes of.
You never heard the minister or the Prime Minister's office or any minister's office direct her to do anything. Is that correct?
No, I didn't, and in fact, it would be very inappropriate for me to have those conversations at that level. That would not happen at my level whatsoever.
So I guess this is what I'm struggling with a little bit, because I want to make sure that we are all very clear. One of the things that I think we all hate is the idea that the work that the RCMP does be politicized, because what you do is incredibly important, and all Canadians should be able to see the work that you do as independent and as in the public interest. So at no point did anyone from the RCMP that we've spoken to say or has heard the minister or the Prime Minister's office or the minister's office demand a particular action in this regard. So I guess what we're struggling is, how do we make sure that the public understands that the RCMP's work was not compromised? How was your work not compromised?
Is that question again, Chair? Is that directed towards me?
It's you.
Well, I'm not sure how to answer that question in terms of how do we make the public understand that our work was not compromised. Our work could very well have become compromised. That's a very difficult question for me to answer.
But you are here before us saying that the minister's office never directed, or you never heard the minister's office direct anyone to do anything. You never heard the Prime Minister's office direct anyone to do anything. You never heard the Prime Minister direct anyone to do anything. Is that correct?
That's correct. I never heard the Minister or the Prime Minister's office direct anyone to do anything. However, there has been evidence before this committee of emails that would suggest a certain or a significant interest in that information from the Minister's office between the Commissioner of the RCMP's office. So whether those conversations took place verbally, I can't speak to that, but what I can say is that I think the evidence is clear that there was interest by the Minister's office with respect to specific information of those firearms via email.
And is it?
Would it be reasonable? I believe your 5 minutes is up, but we had a bit of a timing issue, so feel free to correct me if I'm wrong.
I
believe
may
it's
have a little bit more time.
Over 5, I believe, but.
Okay.
Are you all right with that? Okay. Thank you very much. Half minutes, the Bloc québécois, député Normandin, s'il vous plaît.
Merci.
Thank you very much, Madam Chair. I have some questions for Ms. Scanlon regarding the conversation on April 28th. And keeping in mind what Commissioner Lucky said, which was that she would never take any steps that might compromise an inquiry. Now, do you have the same understanding as Mr. Campbell that Commissioner Lucky understood the risks that disclosing this information could have in terms of compromising the inquiry?
Yeah, my takeaway, my experience from that conversation was the risks seem irrelevant.
Donc, je comprends.
So, Commissioner Lucky understood well the risks, in your opinion, but that seemed secondary to her because she was more concerned about disclosing the types of firearms. Is that correct?
Well, I can't speak on behalf of the Commissioner, so it'd be unfair for me to say that. She could speak to what she understood, and as a police officer, I think she would have a clear understanding of what it means to compromise the integrity of an ongoing investigation, especially one of the largest mass casualty in Canadian history.
I'd like to refer to an email that you sent. It was your team that was in charge of disseminating information, and I'd like to hear you talk about the scope of Commissioner Lucky's decisions, in terms of what should or should not be disclosed during the inquiry.
Again, my communication is not with the Commissioner directly. I communicate with National Communication Services, so Sharon Tessier, Dan Bryan, and Jolene Bradley, my colleague. So I can't determine exactly what the Commissioner's scope was or what. I can only speak to what my experience was, and so on early days on April 19th, we had done a press conference where we indicated a number of victims, and later that evening, the commissioner released a separate number, and again that evening she released another number in one-off interviews, which, unbeknownst to us in Nova Scotia, I actually found out from the media. And we had committed to, Nova Scotia RCMP, had committed to doing a press conference the following day where first order of business, so we'd be updating a number of things, including the number of victims. But yes, so again, that's publicly available. And in terms of issues thereafter, the commissioners, I'm making assumptions. I mean, Sharon Tessier or Jolene could speak more appropriately to this, but at the end of the day, that's who I deal with, and I would make the assumption that they're taking more direction directly from the commissioners. That would be the most appropriate.
Ms. Scanlon and Madame Normandin, the time is up. Thank you very much.
Thank you.
We're going to go into our last 2.5 minute round with MP McGregor. Please go ahead.
Thank you very much, Madam Chair. What I'd like to direct my questions to Ms. Scanlon, and it's in reference to, I guess, the last line of questions I had to Chief Superintendent Campbell. You went into some great detail in your letter, and he did reference that it might be more appropriate for you to answer for yourself, and I agree with him. But just when Commissioner Luckey had made reference to this being linked or tied to pending gun control legislation. First of all, if you could just reiterate your reaction to that. And second of all, with all of your experience in the RCMP, I would also like to get some of your comments on the actions you think legislators need to take, specifically with the RCMP Act, Section 5.1, which kind of lays out what the commissioner's powers are. Because we have seen instances in previous decades where there has been political interference and direction of the RCMP. It happened under the Chrétien government. It happened under the Diefenbaker government. Do we as legislators need to make an effort to reform a section of the RCMP Act so that those guardrails, those legislative guardrails, are firmly in place? Thank you.
Yeah, no, as I stated in the letter that I wrote, and I do have notes also from that day. I have notes from April 28th that were disclosed to the Mass Casualty Commission and federal DOJ that I haven't seen yet publicly, but I do have notes. Yeah, it was as I stated, it was a feeling of disgust. I was embarrassed to be a part of it. I was embarrassed to be listening to it, and message received. I understood exactly what was being said. And then with regards to the latter part of your question, I don't know the act specifically, but I just think it's important that I think it's important that it be examined, and there needs to be a level of independence so that from the selection process all the way through that there's not, there's a very different, a mandate letter and keeping our partners informed or providing information to the Minister of Public Safety or the Minister's office, that's very different than interfering, influencing, or exerting pressure. So I think that words need to be carefully examined, and if it's vague, we should be more specific, so that we're never in this situation again, especially those on the ground who are dealing with the investigation.
Thank you very much. I think that's an appropriate time to conclude. Witnesses, thank you very much for being here today. And I recognize how very difficult this is to discuss. And I very much commend your bravery and your courage of being here today and being forthcoming with your responses. Again, on behalf of Canadians, we very much thank you for bringing your testimony today. And we wish you all the best in the forthcoming weeks and months. Thank you very much. Committee members, we will take a brief 2-minute recess while we allow the witnesses to vacate the room. Thank you very much. Minute recess is up, and we're going to resume discussion about the motion that was introduced by MP Perkins. So if you have thoughts on the motion, please raise your hand. MP Ellis, go right ahead.
Well, thank you, Madam Chair. I think it's exceedingly clear that there continues to be an evolving story here. I think on behalf of certainly the families whom are mostly my constituents, I would suggest that as the story evolves, there are others out there who do know the answers to these questions. And even though perhaps at the current time it is becoming the integrity of those RCMP officers who were on the ground, who made notes and provided those very graciously to the public at large, it's very, very clear that there's more to this story that is not coming forward. And I also would believe that to Mr. McGregor's point, there are other things that need to be well elucidated in terms of the independence of the RCMP. And I think Mr. McGregor tried multiple times to get towards that today. And obviously we need more information to understand better exactly what happened, and I think perhaps equally as important, how we're going to move forward with respect to ensuring that this type of political interference is not allowed to continue. I thought also that Ms. Scanlon made an interesting remark with respect to the choice of the commissioner, how that commissioner is chosen. At the current time, of course, we know it's a political appointment and they serve at the pleasure of the minister. So obviously there's more to be understood, there's more stories to be told, and I certainly think that continuing on with the appropriate witnesses is absolutely imperative, not just for those families and constituents who are affected in my riding, but for all of Canada, so that we can continue to understand that we can have faith in the systems of policing that we have. Thank you, Madam Chair.
Thank you, MP Ellis. Député Normandin, s'il vous plaît.
Ms. Normandin. Yes, thanks. So just a point of clarification for those who are moving the motion. I'd like to better understand what type of information are we trying to get from these witnesses? You know, is there information that would not have previously been disclosed in the committee's previous two meetings? You know, I understand that we're looking to understand the minister's responsibility here rather than the officials who might not always be aware of what's going. So I'm just curious, like, what type of information are we trying to get here, and what type of witnesses might be able to provide us with that information?
Merci, Député.
Thank you.
MP Perkins, please.
Well,
perhaps MP Perkins can respond, Ms. Normandin.
Yeah, hopefully I can. I had my hand up to speak anyway, so I think it's timely. I think primarily when you look at the witnesses, several of these witnesses we've already asked for before, so we're asking for again. There seems to be some confusion on the issue of the provision of the firearm list to the political level. That from emails appears to have happened through the minister's chief of staff. So there is a question as to where did that direction come from? Even some of the Liberal members have raised the issue in questions today, asking about whether or not where the request for this information was coming from. We know from the email stream that it was provided to the minister's chief of staff, and from the text of that, we also know that that it appears to be a response to a request. Secondly, we have had some various testimonies both here and in the Mass Casualty Commission about the role of CERT and when CERT said and what the rules are for CERT in providing that information to civilians at the Mass Casualty Commission. And again here today, those who were provided this on the 23rd were not members of the RCMP, and that seems to be contrary to the CERT's request. So it's important to have a clear understanding of that process in this and whether or not rules were breached. As well, Mr. O'Brien has been mentioned in the Mass Casualty Commission testimony of various people as intervening on things like the messaging around how many victims there were. So he was involved in the communications decision-making process. And obviously he has some background in his life before that that leads to his connections with the government at the political level. Ms. Bayers was also mentioned in the Mass Casualty Commission as asking whether or not on the 28th they're going to release the information. So she was clearly contacted by someone suggesting that that should be done. We need to get to the bottom of those issues. So there's still a lot of mystery in my mind as to where the request came from to send this information outside the RCMP. And I know it wasn't released publicly, as some people said, but in essence, when you're releasing it to civilian people, such as the Chief of Staff, the Minister, the government officials that were listed on Commissioner Lucky's email of the 23rd of April, it's clear that there was a release beyond the limits of what CERT said, and we need to delve into and understand why those requests were made, who made them, when they made them, and why they were requesting to go around the normal police procedure in this terrible incident. So I think there's a lot of clarity we still need to get from these witnesses, and that's why I put them forward. Thank you.
Thank you, MP Perkins. MP Damoff.
Thank you. Thank you very much, Chair. And I would respectfully disagree with my Conservative colleagues that there's still a lot of questions that need to be answered. I think the information that we've received in the two meetings that we've held already with the Minister, the Commissioner, who were both clear, very, very clear in their testimony that there was no political interference. The testimony that we've heard today from the Department of Justice that there was no political interference in what was released to the Mass Casualty Commission. And even in the testimony that we've heard in the last panel here today, I want to be also stress that this new motion that we have received, that only two of the witnesses were on the list previously. They were invited, as my understanding, by the clerk and were unable to attend today. So I would like to propose an amendment to the motion that we've been put forward, Chair. The amendment would, that pursuant to Standing Order 1082, the committee, and then everything after the words committee be removed and replaced with convene a meeting for committee business to determine if it wishes to continue the current study, and if so, what witnesses should be heard from, and that meeting be held after September 19th, 2022.
Thank you, MP Damoff. Are you able to send that amendment to the clerk, please?
I can. I do not have it in both official languages, but I will send it to, it's not very long, so I'll send it to her in English.
And may I just ask, while you get that done, can I just ask as a point of clarification for those, since you've read it once and just want to make sure I'm clear on what the amendment is looking to achieve, so that we would convene a subcommittee meeting, which would be an in-camera meeting, to determine if we wish to continue, and if we do, what witnesses would be invited, and that we should have the subcommittee in-camera meeting following September 19th. Is that correct overall?
I actually did not specify that it was subcommittee, Chair.
Okay. Pardon me.
But I did say after September 19th, so it would be up to the chair to call a meeting of committee business. Now, normally we do it in camera. So, I mean, I would be open if someone wanted to add that to my amendment, but at this point it just says to convene a meeting of committee business after September 19th to determine if we want to continue.
Okay, so the motion does not specify in camera, so otherwise it's in public then.
That's correct.
Correct. Okay. Okay. So this is officially moved then, clerk, and then we are debating the amendment now. MP Lloyd.
Thank you, Madam Chair. My concern with the amendment, and perhaps Mr. Moff can clarify for this, is that if the chair, the chair can call a meeting after September 19th to discuss committee business. There's no timeline that forces him to call a meeting right after September 19th. They could delay it. And also, I don't think there's anything in your motion that states that the committee business has to prioritize a discussion about what we want to move forward on with this. So we could have a meeting about committee business, and somebody else can put up their hand and totally change the complete subject of what we're discussing here. And so I would like some assurances that, and not necessarily, I'd like some assurances that if we did have this committee business meeting, that the committee business would be primarily and prioritize that it would be about this study, and that it would happen in a timely manner as soon as possible, even before September 19th possibly, or right after September 19th, not later in October or in November. And secondly, on the original motion, which is now being amended, I think it's very important that we have email evidence that shows that the Chief of Staff, Zita Astravis, was in communication with the Commissioner on the subject of the public disclosure related to the mass casualty event. And I think we've explored a lot of different sides of this issue. We've explored the Department of Justice, obviously, the RCMP, the minister himself. But what we haven't explored is the connection in the minister's office, which we know exists. And I think it behooves us to look at every corner of this. It's not a fishing expedition. We do have the evidence that there was discussion between the Chief of Staff and the Commissioner. So this is an important link. And I'd like to see, something productive come out of this study where we can say, here's where there was a mistake, whether or not it was political interference, or if it was a misunderstanding, or if it was a breakdown in the protocol, or if somebody's responsible for a severe lack of judgment, which I do think is the case here. I think we need to have those witnesses so that we can have a comprehensive report. So that's my concerns with the amendment, and I'll rest it there. Thank you.
Thank you, MP Lloyd. MP Perkins.
I think MP Ellis was up before me, but I'll leave that.
My apologies, MP Ellis, and then MP Perkins, and then MP Noor Mohammed.
Well, thank you, Madam Chair. I appreciate the recognition. That being said, I can't underscore enough the seriousness of these allegations and the seriousness that it creates in my riding of Cumberland-Colchester. People do not have any faith at the current time in the Mass Casualty Commission, and to continue to use the testimony that we have already heard with written notes from a very, very reputable member of the RCMP, and to question his integrity is an absolute travesty. We also had corroboration today from Ms. Scanlon with respect to what she heard in that meeting as well, also with notes, which obviously we will have access to as well. That being said, I think it behooves us all as parliamentarians in Canada's worst mass shooting in history that we take this very seriously, that we obviously do understand in the vernacular, somebody's not telling the truth. And that is very, very disappointing to me. And I think it's very disappointing to Canadians at large. And for that reason, I would certainly not be supportive of this amendment. Thank you.
MP Perkins, please.
Thank you, Madam Chair. The amendment to my motion seems to just delay what we're doing here today. I mean, the reality is that we know we are missing these key links in the chain of potential political interference in the largest mass shooting in our country's history. And the delay of this till after September 19th, for those who are watching September 19th, that's when the House resumes, to have this discussion, which we can have today. And we've given adequate time for those witnesses who have already been mentioned twice in motions before this committee to find the time to come here in September. If we wait until September to discuss this, given committee business on other studies, it's going to be further delayed. And there is a bit of urgency. The Mass Casualty Commission does have a deadline this fall, and it has reporting deadlines. We need to continue our study as soon as we can to get these folks there, particularly in the confusing testimony that's there with what we've seen from the Chief of Staff's clear requests on April 22nd and April 23rd, all around the cabinet meeting, that was held that day on this issue, asking for details that the civilian level was not entitled to. And the only people that can answer for that are the people on this list. And they have not been allowed or enabled to appear now. And we need to hear them, or this committee's study of this will actually be questionable in any conclusions it comes to.
Thank you, MP Perkins. MP Noor Mohammed.
I have to confess, listening to all of this, just a reflection. First of all, we've now heard the commissioner of the RCMP say she wasn't pressured. We've heard the minister say that he never pressured anybody. We've heard political offices say that, we've heard that no political office pressured. And we've heard two reputable members of the RCMP, in particular, Chief Superintendent Campbell, say that he never heard the minister or political offices, the Prime Minister's office, pressure or direct the commissioner to do anything. So with that backdrop, and with the fact that we are now seemingly we have this desire to replace the work of the Mass Casualty Commission, which we should not be doing, I would recommend and I would like to move that we just adjourn debate now.
Thank you, Noor Mohammed. I will say it's disappointing that you do not allow the NDP to speak. Do I have an opportunity to say, can you rescind it? To allow NDP? No, we don't. Okay, well, we'll go to a vote. And we'll call the vote. And I go to the Liberals first. You go ahead, sorry.
On the motion that debate be adjourned, Mr. Chiang.
I vote yes.
Ms. DeMoff.
Yes.
Mr. McKinnon.
Yes.
Mr. Noor Mohammed.
Yes.
Mr. Shefke. Mr. Lloyd.
No.
Mr. Perkins.
No.
Mr. Ellis.
No.
Madame Normandie.
No.
Mr. McGregor.
I'll abstain.
So 5 yeas and 4 nays.
The vote to adjourn passes, and the meeting is adjourned.
No.
Madam Chair, point of order.
I'm sorry.
No.
I got bad advice. Sorry. My apologies. Please.
Just only debate was adjourned.
Oh, the debate. I'm so sorry. The debate is adjourned.
Point of order, Madam Chair.
Okay, please. My apologies, colleagues. This is my first experience with this situation. MP Lloyd, go ahead.
Is it my understanding that maybe the clerk can answer that the adjournment on the debate is on the sub-amendment or the amendment by Ms. DeMoff, or does this dispose of the debate on the amendment and the sub-amendment together?
The clerk's opinion or professional advice is that it adjourns the debate on the motion in its entirety with the amendment.
Understood. Madam Chair, I'd like to move a motion.
MP Lloyd, go ahead.
Yes, the motion is that pursuant, and I think maybe there's a bit of a compromise here, pursuant to the meeting, that the committee agree to hold a meeting to discuss future steps with this study, and that this meeting be held between September 19th and September 30th of 2022.
Point of order.
Thank you, MP Lloyd. MP McKinnon on a point of order.
Yeah, I believe that that is repetitive business. We've already dealt with this issue substantially with the motion, which has now been adjourned. So I think that the Mr. Lloyd's motion needs to be out of order.
We're just going to suspend for one moment while I consult with the clerk. proposed new dates of September 19th to September 30th that the committee meet in. Can you just please repeat that? The clerk is just wanting to see how if it is substantively different than the other motion.
I'm proposing that the committee meet to discuss committee business between the dates of September 19th and September 30th to deal with the question of how to move forward with this study.
I think that is substantial and it's different than the original motion, Mr. McKinnon, so your point of order does not stand. Mr. McGregor.
Thank you, Madam Chair. Yeah, I was just going to actually object to the point of order. I did think it was substantively different, and I think I congratulate Mr. Lloyd. I think a good compromise has been reached, and it actually echoes a sub-amendment I was going to move to the amendment. So I think this is something that hopefully we can all agree to, and I'll keep it at that with hopefully us getting to a vote.
Thank you, MP McGregor. MP Damoff.
Thanks. And just before I speak, Chair, I'd just like to commend you on what you've been able to do today. I know you were put in the position of taking on the chair at the last minute, so I'd just like to thank you for very valiantly leading us in this meeting. And to my colleague, Mr. Lloyd, that's essentially what I was trying to get to with my change to the original motion, and we would be supportive of a meeting being held between September 19th and September 30th. So we'd support your current amendment on the floor.
It's a motion, but I believe your point stands. Yes.
Sorry, motion on the floor. Yes, sorry
Thank
about
you.
that.
If I see a few hands up, but I think that they're just holdovers from when the individuals spoke. Are there any other comments? Let's go to a vote. It seems to be agreement. We don't need to vote if there's general agreement. Are there nods that we can have this motion pass? I'm seeing thumbs up from all parties. Okay, then the motion is passed. There's no other comments. Just going to one more moment to see if there's any other hands up. I don't see any from anyone. Oh, Madame Normandin, please. And then Mr. Shifke, right? Yeah. Go ahead.
Yes, I just wanted to know if it would be possible to get a written copy of that motion in both official languages. Thanks. Just so we can get the exact wording.
Yeah, absolutely. The clerk will provide that in short order and within the next day, I would think. Yep. Yes, within the next day. Merci. MP Shefke.
Mine was just a simple motion to adjourn, Madam Chair.
I think we can all agree on that. I see nodding and thumbs up. Meeting officially adjourned this time.